practice came from Houston here in Portland. And I shudder to admit that I've been practicing law longer than most of the young faces here have been alive, 30 years. I'm head of our terms litigation group, and among our good clients, probably the reason I'm here today is the court journalists, but we also represent a variety of other businesses, public and public agencies in the litigation world.
Well, I'm Ken Lanfear. I'm the director of team sports. I work in football and I work in baseball. I'm a graduate of Santa Clara University Law School. I've been at this ever since I was in law school. I actually began while I was in law school as an intern and never looked back. Arbitration, of course, is a very interesting topic, so I'm sure we'll have a good, thorough discussion of that today. Because I work in two sports, which is fairly unique for an agent these days, I will say that baseball is probably a bit more of an appropriate topic. Football certainly has and involves arbitrations, but we can look forward to talking about the difference.
Thank you. My name is Maureen Weston. I'm a professor at Pepperdine University in Malibu. I wanted to thank Max and the U of O Sports Law Society for having me here. At Pepperdine, I teach a range of courses on dispute resolution, so arbitration, mediation, and negotiation. And those fold into my sports law practice and teaching, and I have a particular focus on Olympic and international sports. So happy to be here. Thank you.
Okay, well, without further ado, we're going to go ahead and get started. And what I've done is I've come up with questions, most of which are a little bit more sophisticated, but some of the initial questions are going to be more basic, partly because we do have a student-heavy audience, and we want to make sure that people understand what we're talking about when we talk about arbitration and how it would differ from going to trial in like a court case. So, without further ado, what is arbitration? What is it designed to accomplish? How is it different than litigation?
So I'll start out with the professor definition, and you guys tell me how it really is. But arbitration is a process where parties agree as a matter of contract to have their dispute decided by preferably a third-party neutral, so it can be one arbitrator or a panel of arbitrators. It's really it's by agreement, and it's basically a private trial, and the rules of evidence we were talking about, it's by agreement. In the sports context, that's a question of whether the parties or the athletes truly agree to this process, but it's the process that they have in place so that you can have a quick disposition of the disputes, so eligibility, any of these type of questions. But what's also different is the parties select the decision maker, and it can be party appointed or having one arbitrator serve. What's interesting about arbitration, it's privacy aspect, but also that it's a final and binding decision. So an arbitration award is actually better than a judgment because you can have that enforced, and it's very limited grounds to have that arbitration award vacated or overturned. So you don't have, it's not tied up in appeal. So the state benefits are that it's faster, more efficient, but you do have that binding aspect to it.
I won't be nearly as professorial in describing it. For me, arbitration is an incredibly practical tool. From my perspective, I think, frankly, from the perspective of a lot of people who are living in the legal profession, they probably wish it was utilized more. It has its disadvantages, but it's highly efficient. It's far less expensive, although there are some lawyers who would obviously prefer the litigation route for billable hours and whatnot. But the reality is in sports, the fact is arbitration is there to preserve relationships, not to dissect or interrupt them. As a practical matter, you have an employer and you have an employee, and as such, you want to preserve that relationship. But when you have a difference of opinion, typically about compensation or some very serious other substantive issues, you have to have means and a method by which to arrive at a fair conclusion while preserving that relationship. It's critically important, and it applies to a lot of things in virtually any career that you might talk about?
My subjective experience with arbitration is in the trenches slightly different. I would say that the business world has traditionally liked the arbitration process for 3 reasons. 1, confidentiality. 2, finality. 3, price. With respect to the price part, and I would say also the length of time it takes, in my subjective experience, the cases that actually go to arbitration where there's a significant dispute involved and competent counsel on both sides willing to fight the fight, it's a bit of an illusion to think that it's cheaper, and in my experience, it oftentimes is not a lot faster. It is, however, still right, and the result, as Ken said, as Maria said, is not appealable. So at least the thing's done, they don't have to worry about going to the 9th Circuit or someplace for a couple years after that. But beyond that, I think that it's simple or easy to achieve, at least in my experience, is often not the case.
The only thing that I'm going to just add to the other panelists is that when you go to arbitration, it does tend to be typically much less formal than if you are presenting a case to a judge in a courtroom. Your rules of evidence are a lot looser, and in arbitration, things like hearsay can actually come in an arbitration, although the arbitrator may not give them very much weight. And there are some differences in that way, which when I switched from doing predominantly court cases to predominantly arbitrations, I found that to be quite shocking initially, the lack of formality, but it is, I think, much more efficient. It can be cheaper. The difference between being able to go to trial, for me, in a case where a client's member has been terminated for reasons that we don't think are just or whatever, being able to take that to arbitration, you might be able to get that person their job back and back wages within 6 months. And you just can't do that if you're doing court litigation. It's going to be 2 or 3 years before that ever happens. One of the other questions that I wanted to ask is just kind of a general question about arbitration is the difference between binding and non-binding arbitrations, and what are the benefits of doing a binding arbitration versus a non-binding arbitration? Why would you choose to do, for example, a non-binding arbitration? What would be the point if you're looking for that?
Yeah, go ahead.
I don't really see the point of non-binding arbitration if you're going to spend the money to go through the process, other than it's a dress rehearsal to give you information, just as you might do a mock trial and get a jury assessment to give you information about the settlement value of the case. But the benefit of arbitration is that it's binding and final.
Yeah, I've heard it stated that non-binding arbitration really isn't arbitration. It's really mediation. What's the difference between mediation and non-binding arbitration? I think the point is to try to resolve the matter. And so arbitration to me means binding arbitration. And that, of course, is what, in my very narrow field of endeavor, has been the case throughout, particularly in baseball and in football, whether you're talking about compensation issues, which is probably the best known, baseball arbitration being an example. In football and baseball can run the gamut from injury type of disputes to a variety of other types of disputes, but they're all binding. And in the case of baseball, as we all know, you're taking one party's position over another. There's no middle ground. It's one or the other, which can be very intimidating for the parties that are involved, and that's why arbitration is designed to promote settlement, at least from my perspective. It's not designed to go to war. It's designed to cultivate agreements. And when you have extremes, like you do in baseball, for example, the parties often suffer trepidation in the 11th hour because the reality of losing is so great, it often brings them back to the bargaining table.
I've never done a non-binding arbitration, so that probably tells you what I think of that there is a program in Oregon State Court for non-binding arbitration of smaller tort claims. The idea that people go into those kinds of things with an unrealistic expectation, and that perhaps a little dose of reality, which is sort of akin to a form of mediation, really, will lead to a settlement. But there's really not much point in spending all that much money in a business dispute or, in my experience, anyway, in an NBA or a player dispute.
And I agree with Kevin. I think that the uses of non-binding arbitration are quite limited, and it's usually not going to be something that is going to happen if you were talking about a lot of dollars at stake or clients that want some sort of finality and want to move on to the next topic that they need to deal with in their relationship. One of the things that I wanted to make sure that the audience understands is that the way that arbitrations typically work, because it is by contract, if the subject matter that is in dispute is covered in the contract, the parties are required to go to arbitration. They cannot file a lawsuit in court or take any other kind of legal action to try to enforce the rights that are under that contract. If they both agree, if both those parties have agreed that that's how it's going to be resolved. And so I think that, when Ken was talking about that, the parties who sat down, they've agreed this is how it's going to be done, and particularly with baseball arbitrations. And there are other types of disputes that are covered in different sorts of contracts where you have parties who have agreed this arbitrator that we pre-select is going to decide you win, you lose, this is the monetary deal that's going to happen. And it really does help to promote some sort of a negotiation, because the all or nothing aspect can be really complex. And if the arbitrator isn't allowed to come up with some kind of middle ground, there's just a lot that ends up writing on the final decision. What are some of the typical concerns in arbitration that lawyers have to deal with?
The arbitrator. Who chose the arbitrator? Who's on the panel? What are their political persuasions? What's their track record? Is there a political aspect to it? I don't think it's probably far different than what you might view in terms of a more conventional litigation proceeding involving a judge. That's actually one of the real problems in the NFL today, is that in the vast majority of cases, except for the use of performance-enhancing drugs, whereby the commissioner finally acquiesced to allow the union and the league itself to jointly select the arbitrators. The vast majority of the time in the NFL, the arbitrators are selected by the NFL. And on a more modest basis, for example, every Tuesday, typically Tuesday being the off day for an NFL player, I often will do hearings that are in essence in front of the very person who handed out the traffic ticket, who's ultimately making the decision. So that's my greatest concern. In baseball, arbitration, of course, has been a boon to the players. It's an incredible vehicle platform for them. It's completely altered the landscape of the industry. And I was there at the very cutting edge of it when it first got started as a young person still in law school. And I knew then and learned soon thereafter that the most important part of the process was the selection, not only a jury selection of the arbitrators that were going to hear the cases. And so you're at the whim of really almost like a lottery, which arbitrator we're going to get. And then you have to appeal to that arbitrator. And that actually can shape your, you don't even do the filing number at that point. You actually got to file your numbers, you know who your arbitrator's going to be. So it's a roll the dice. And that can profoundly impact your negotiation.
In my experience, it's quite different depending upon the arena. Under the current collective bargaining agreement between the players union and the NBA, you really have only two choices. A grievance arbitrator that is jointly selected for a period of time to handle all player team grievances, jointly selected by the league and the union. So you know who you're going to get in advance, and you know, you can do some intel, or you can talk to other teams, or if you're on the union side, you talk to your folks about what this person's particular biases or predilections are, but you're stuck with that person. If there's a dispute between teams in the league, the arbitrator is the commissioner. So you know where his designate, so you know what you're dealing with there. On the commercial side, sports teams are businesses, and that's, I often tell folks in groups like this that I don't personally think there is such a thing as sports law. It's you're practicing law in an arena that happens to involve the business of sports, and of course, labor law, commercial law, contract law, property law, ad nauseam. But in a commercial arena, whereas Maureen said that the parties by contract agree to arbitrate, typically there's a commercial arbitration service involved, like you're an arbitration association here in Portland, your arbitration service in Portland, and you get a list of arbitrators that they select from their panel, and you can strike a certain number of them, and the other side can do the same. And if there's a match, then the moderator of the AAA say, we'll pick the arbitrator, and if you don't, then they'll just pick one, and that's what you're stuck with. And the intel that Ken is talking about, you would do from your list and decide who you want to strike.
In my experience is more along the lines of what Kevin was talking about. I typically would get a panel selection that we then go back and forth to strike particular arbitrators. We know certain ones we don't want. Assuming that my opposing counsel did the same thing, they're certainly going through striking certain ones that they probably feel are more labor friendly, and eventually we end up with somebody. And generally, I would say that in Oregon and Washington and the other places where we do arbitrations, we have been, I think we've been pretty fortunate. Most of the arbitrators in this area seem competent. They are relatively sharp. I don't usually have concerns about an arbitrator not understanding what the presentation is going to be. And so that's been fortunate. There's been a couple times I've had some concerns, but for the most part, I would say that most arbitrators at the end of the hearing know what they're doing. But you always do want to pitch to your audience, and so knowing who the arbitrator is does help me to determine how I'm going to frame my case, what's going to matter to that arbitrator, or what do I think is going to matter to that arbitrator. I will look at opinions that might be published that the arbitrator has authored. I'm going to also request informal opinions oftentimes from other people I know who practice in the same area, because I can see how the arbitrator thinks about the issues. And if I'm lucky, I might even come up with a few cases where they've made some sort of a determination that might be similar to the case that they're going to hear from me, and that helps me tremendously in terms of arguments. So in that way, it's similar to how I would prepare for a court case if I know who I have to judge.
I just wanted to emphasize this idea that Ken was making about the power of the arbitrator and how critical that decision is on who you select as an arbitrator. And unlike in law school, we start with appellate court cases or Supreme Court cases and maybe a trial court decision, but that's not going to be your practice. Your practice is going to be in arbitration and mediation. That's how cases are settled. In a court case, you just draw the judge. You don't have any control, but you don't pay the judge. In arbitration, you do this whole background check, even with judges, you do the background check, but this is where I want an arbitrator who's going to be favorable to my client's cause. And you're also paying the arbitrator, they're working for you, and you're defining the arbitrator's powers in the contract. And playing to the audience in the international context, athletes in international sports and in the Olympics go before an international court of arbitration for sport, and it's judges from, there's a whole talk about playing to your audience. It's one thing to have jury appeal, and American advocates and lawyers come in with trying to wow the jury. That doesn't work before international arbitrators. They don't want any of that. It's like very limited, one-page briefs, and then sit down. So it's a critical decision.
Do most of the cases that the panelists try or have set before arbitration, do most of them settle before the arbitration actually happens, or do most of them go to arbitration?
In my case, I don't think that arbitrated cases are much different than the litigation arena. Most cases settle. I think the last statistic I saw for civil lawsuits filed in the federal court system, and maybe it was 2012, less than 2% of the cases went to trial. That's a pretty dramatic change from when I started practicing law 30 years ago, but I think that most cases, most disputes, and that's what they are, whether they're resolved in the arbitration arena or in the courtroom or otherwise, are resolved, and most of them are resolved otherwise, that is, out of court.
I'll just give an example from the international sports model. In doping cases, so if there's been an allegation that an athlete has violated the World Anti-Doping Code, then there's a fixed set of sanctions, and they have to go through that process. So we've tried to promote more mediation and negotiation in this process where the parties have control. So that's a distinction between negotiation and arbitration. Is arbitration, you're ceding power over the decision to the arbitrator, but in negotiation or mediation, the parties are working to craft their own settlement. So that's the ideal, is to have that control. But in team selection disputes, in doping cases, the USOC has said we can't really mediate those type of cases because the athlete either committed a violation or not. And so the doping cases go to arbitration.
Yeah, as mentioned earlier, arbitration is a tremendous device to promote settlement. So as per the panel's comments, I would agree with that. Although I will say that there are trends from time to time. I'll go back to baseball since it's such an extreme example, a relatively highly visible example of arbitration and its impact on an industry. When we first got started years ago, at a time when the players were actually better prepared than the clubs, because the clubs typically had GMs, not lawyers per se, negotiating, and they were getting their butts kicked basically. And there was a high percentage of cases that actually did go all the way, as we say, or settle on the courthouse steps. Then there was a long period whereby there was a lull, and that's been the case for quite some time in terms of arbitration cases actually seeing an arbitration panel. We're now starting to see a little bit of an uptick in Major League Baseball. There are some teams that are actually showing a willingness to go a bit more for a variety of reasons. But again, it's there to encourage people to talk and to come to a meeting of the minds, if not out of mutual understanding, out of fear and apprehension.
What are some of the typical techniques that you use during arbitration? What kind of information do you generally present during an arbitration? Do you invite your client to attend if you're having an arbitration?
That's a great question. And as I mentioned earlier, when you're talking about employer-employee relationships, oftentimes, particularly again in the case of baseball, I use it because it's such a good example to utilize. You've got often the fragile ego of a professional athlete who's going to potentially sit there and hear from his employer how bad he is. And employers who truly cover that player, and they do if they're in arbitration because they want that player to be retained on their roster, you have to properly inform your client as to what they're about to endure. But however, it's really important that your client is there. The client provides, I think, a bit more of an incentive for fairness, reducing unfair play or comments. People are far less inclined to say something that's a bit out of line. And again, remember, arbitration isn't controlled by the types of factors that litigation is. The rules of evidence, how far you can go, it's not as limited. But you have to be careful too, because you have to remember that the arbitration panels are typically judges who have made their living operating as judges and following the rules of evidence. So I've seen many a lawyer make the mistake of overstepping their bounds in arbitration and insulting the judge or drawing a very strong reverberation that can really hurt them. So it requires tremendous self-discipline. It's not the Wild West in arbitration. There are a lot of lawyers that think it is, And you have to be very mindful of that, and that gets back to knowing the persons with whom you're talking to.
I'll address the circumstance primarily of commercial arbitration in Oregon. But before I do that, I would say that because of the salary cap and salary rules that the NBA has, traditional arbitrations over salary issues are quite rare. They usually only occur between a team and player if the relationship is already severed and there's not much of a relationship to protect. So the goal of keeping the velvet glove on the fist is really not there. It's to win. So in my experience, it's the often settled, but if you go in there, the evidence presented is much like you would see in a trial. Perhaps a bit more abbreviated, a little looser in the sense that we're not going to worry so much about hearsay rules, but frankly, experienced advocates don't really have a problem with that anyway, in my experience. So that's the NBA side. On the commercial side, Oregon is a small provincial place in many ways, and one of the subtexts in every arbitration I've ever been in, commercial arbitration in this state, is that the arbitrator has, the panelists and members of government, is paid by the parties. And a good arbitrator who does a lot of that work wants to preserve the relationship with the lawyers who will hire him or her. And so oftentimes there's a tendency to maybe split the baby or to try to get the parties to settle so that one group of lawyers or the other doesn't get mad at you. One of my partners who's sitting here, John Monson, and I had an arbitration last year in which it was fairly clear to us how the arbitrator should rule after he took the matter under advisement. But frankly, he delayed it for months, and our speculation is that he was hoping that the parties would settle so no one would be unhappy with the result.
I just want to add, I think it's an interesting question, and the context makes so much difference. And what's the ultimate goal? Is it to maintain the relationship? So in a salary arbitration, you don't want to go too far. And the question is, do you have your client there? Because if you're saying, oh, that player's all washed up, I mean, your goal is basically to get the best price you can for the player, but that's going to ruin the relationship if you're there criticizing the player. Whereas in other contexts, a disciplinary proceeding, or you want, I've been involved in these anti-doping hearings, and the anti-doping agency doesn't care about the long-term relationship with the player. In fact, they think the athlete's a doper and should be out of the sport altogether. So it's, the context makes a big difference.
And I would also agree with that. Most of all arbitrations that I do now are all in the labor context. And so in the context of any kind of a collective bargaining agreement, you always have to think about the relationship between the parties first, because that's really what the purpose of the agreement is. It's to facilitate a working relationship. And you take those cases to arbitration that are either really important because it's, the membership has a particular issue that for financial reasons is important, or for assignment of work reasons, or some other major issue that they are really wanting to have arbitration, or if you have a discipline issue, which is also really important to the membership. So you're always thinking about the membership, and you're also thinking about the employer. A lot of the cases that are raised initially through a grievance process in a labor union context do get resolved before they go to arbitration, either because the parties have agreed on some sort of settlement, some lower level of discipline, or some way to interpret the contract going forward where they are going to agree to pay a little bit more for certain types of assignments, work assignments, or whatever the issue is. But there are those issues that just aren't going to resolve, and you have to go to an arbitrator and try to get their opinion so that you can move forward in that relationship. And that does, I think, have an impact on the kind of evidence that you present and the nature of how you treat the witnesses that you question, because you are still also in a relationship oftentimes with those witnesses, even if they are management witnesses. As an attorney, I, in some ways, would be less aggressive in arbitration, not necessarily in the nature of the questions I ask, but the way I ask them, because it's just a very different context. We always have our clients there. I think we think it's very important for the client to be there, for the agreement to be there, for them to be involved in the process and to see how it works, even if we don't know if the outcome is going to be successful or not.
Let me just add on that. I've had lots of clients over the years, typically business clients, that maybe think they're doing whatever proceeding I might be litigating with them, who say, I don't want to come to the trial, or I don't want to come to the arbitration. Can I just not come? The answer I always give is no. You have to be there. You must demonstrate that this is a concern to you, and show up and pay attention.
Yeah, I just want to emphasize that's a very good point for that reason and others. And it's also important too because I think it's important for your client to ultimately bear witness to your work product and understand the job that you actually do. It's very abstract to most people what we do. And so for them to be able to see in a much more concrete way what you're able to do, how you convey yourself, the kind of case you put together is extremely important.
That actually brings us to another question that we talked about, which is how do you manage your client's expectations? And I think, at least in my experience, managing clients' expectations and managing the client, I think is a huge percentage of what I do as a lawyer, much more than I ever would have thought as a law student. And even doing litigation, that's a huge part of what we do. Is managing their expectations and managing the client so that they understand what the process is, what the end result may or may not be, and how we're trying to get there, and conveying that information in a way that a layperson can understand who isn't a lawyer, and where they can get some understanding of that they may not win the arbitration and what will happen if they don't win, and making sure that you have those difficult conversations with them in advance of the arbitration, because otherwise I think you're in sort of grave danger of either losing a client if you never have that conversation with them and you never talk with them about the possibility that they may lose. They may have in their mind that this is an open and shut case, they have 100% evidence on their side, and as any lawyer knows who's ever tried cases, even if you have awesome evidence, you still might lose. You could draw a bad decision maker, you could end up with some weird evidence that comes in during the arbitration or during the trial that you were really not expecting. Hopefully you anticipated everything, but you just never know. So you have to have those difficult conversations.
2 comments. Whether your client is a multinational corporation, a sports team, or an individual, no client likes surprises. So and also I would say I don't think too many of my clients would be all that keen on the idea that I'm managing anything for them, especially their expectations. What they want to know is what's my chance of success, what's the upside, what's the downside. They may want me to cheerlead. I tell them the cheerleading role is for the arena, for the public, but we're not going to play that role behind closed doors. I have an obligation, and I think it's the right thing, to tell you honestly what I think. And if you don't like what I think, that is your right. You can get yourself another lawyer, but I'm not going to sugarcoat it for you. And I have found that most clients appreciate that sense of candor. I would also echo the comment about the uncertainty of litigation. That's the one certainty in litigation or arbitration is uncertainty. After I won my first jury trial 30 years ago, I was talking to one of the old consultants in my law firm, and he told me that I could not consider myself to be a trial lawyer until I won 10 cases I should have lost, and lost 10 cases I should have won. So that's the nature of the business.
The finality of the arbitration, because clients want you to keep going. They think that we can, even when you have an arbitration where let's try to get it vacated, well, it's going to be tough. There's very narrow grounds to do that. So I explained the finality. And I was just thinking of client expectations in A-Rod's case against baseball, where it reminded me of Lance Armstrong and Floyd Landis, where they were calling arbitration a witch hunt, a kangaroo court. It's lawless, and so their expectations that they should be able to keep fighting and have the public in on what's happening talk about wild expectations. With a lot of these athletes, their egos are enormous. So for them for you to educate them that this is how it works, and it's not like it is on TV. You can't be that grandiose. It's something that's difficult to impart because they want to continue fighting like A-Rod was doing. One thing I wanted to mention is in the international sports context, most of these athletes do not have lawyers. They're not represented at all. They're required to go to arbitration as a condition of participating in the sport, and they can't afford a lawyer. And so talk about client expectations, oftentimes they go in unrepresented, whereas the authority, the prosecuting authority is funded. And at the Sochi Games and at the Olympics now, they have on-site arbitrators. So the arbitrators commit to turning a case around, giving a decision within 24 hours. But the athletes are still unrepresented, so they've now called for enlisting pro bono attorneys, local attorneys, to help the athletes. But those attorneys don't really know the sport the way the others do. So that's a tough one for the athletes who go into this process and don't have the funds to pay for representation.
So in Sochi, they would have called in who was legal team?
Yeah, they do.
Perfect.
I think it was the right thing.
Yeah, in the sports world, it's, I think, a little more extreme. I think most people are probably aware of that, even from the outside looking in. I mean, there's more of a sales orientation. You don't have the solicitation limitations you may have in a more conventional legal environment. A lot of the agents aren't even lawyers. So the fact is, you also have a highly unique potential client in the form of an athlete. I won't even spend the 3 or 4 hours I could do talking about that. The fact is, I tell the other agent and or lawyer that the most important thing you can do is manage expectations. It's far and away more important. Broadly speaking, I mean, virtually every client you're ever going to represent, it is the most important factor. There are times when your acumen as a lawyer and or a negotiator can truly make a difference in their careers and their lives, and it does separate the men from the boys when it comes to your overall comprehensive ability as a lawyer and or an advocate. But by and large, it's about managing expectations. The problem in our field is that there's far more salesmanship than substance. There's far more hype than anything else. So the vast majority of people in my business, they oversell and underdeliver. And when you sell someone, when you try to ultimately, lawyers are out there selling too. I mean, let's be honest, in many cases. The fact is, in order to get the client, sometimes you've got to say things that perhaps aren't necessarily deliverable. And that's just the reality, I'm just being honest with you. In my profession, that happens far more probably than in most. So you have to be very careful. My philosophy, even when I was younger, was always take an educated approach. Don't sell, educate. It's very important because where you establish that relationship in terms of common understanding and their ability to understand what it is you do or what they're about to endure is incredibly important. You don't want to have to re-recruit your client. And there's far too much of that. So establish a reasonable level of understanding. Make sure your client understands what you can do and what you can't do. And it's an ongoing challenge no matter how you start, but that's really, really important.
Have any of you ever had any ethical issues come up in preparing for an arbitration or in the arbitration itself? If so, what is the nature of those ethical issues and what did you do? And I have a personal example I can share if no one else wants to. And I had a recent arbitration where the grievant was asked a question by the opposing counsel on cross-examination, and the answer that he gave was not correct. And having worked with the grievant, I understood that the grievant was probably not understanding the question, but the answer he gave was not factually accurate, nor was it the same as we had talked about previously. And so I knew that the testimony that he had given was frankly not true, right? So what do you do in that situation? I have had that situation come up before in depositions as a lawyer when I was doing more federal court litigation, and I'd always take my client out. We'd have have a discussion, you come back in and correct it on the record, right? And that's just what you do, you need to do that. And so that's essentially what we did in this case. When he was done with his testimony on cross, I asked for a brief recess, went out in the hallway, we had a brief discussion, he came back in, he sat down, and on redirect, he corrected the testimony that he had given. And I just want to bring that up because I do think that it's important to keep in mind certain ethical issues that and obligations that we have as attorneys. It doesn't mean that you cannot be a strong advocate for your client, or that you can't be a strong advocate in the proceeding if you have to do something like that. But I think that it's important both in terms of preserving the integrity of the process and also in preserving the integrity, frankly, in front of the arbitrator. The information that's presented, someone else could come in and impeach what your client just said, and it just creates all sorts of other problems. So that's something that I think is important to keep in mind.
A couple of examples. A few years ago at Pepperdine, we held the first public international sports arbitration. So typically they're private, but there's a provision under the U.S. Amateur Sports Act for the athlete to call for a public arbitration, and it's just never been done. But Howard Jacobs, Landis's attorney, decided to see if we can do this as a public arbitration. It was a circus. So a couple of the issues that came up there at the international level, the arbitrators were arbitrators on this case, but the advocates were arbitrators on their cases. So there was a revolving door where the arbitrators they're not full-time judges like judges are. They have a law practice and then they serve as arbitrators, but they were arbitrators on the other attorneys' cases. And so that was an ethical issue that came up as a conflict of interest, and do you have a duty to disclose that? So that was one question. Then the other one was more salacious. During the hearing, Greg Lamont was called on behalf of the doping agency, and it turns out that Landis and his business manager had called to threaten Lamont not to testify, that if he testified, they were going to out that he had been sexually molested as a child. And this came up in the testimony. So then the question is, well, arbitration, is witness tampering a problem? Do those rules apply in arbitration? And then also the question was, did the attorneys know that this was going on? And the attorneys, I'm going to take with their word, claimed to be shocked as this came out during the hearing. But that's a question of, what duty do you have to disclose that your client's engaged in misconduct? And is it really misconduct if it's arbitration, because it's kind of this closed, flawless proceeding?
How do you approach arbitrations where your client wants to take an unreasonable or unrealistic position?
Ultimately, the client has the final say about the position that they want to take with respect to their dispute or in a case or in an arbitration. But in my experience, if the lawyer's advice and the client's desire are at odds, you're asking for trouble. Because either the result is not going to be what the client wants, or you're not going to get paid, or both. Or maybe if a client like that, you've got to think, are you going to be the next one in the dock? So I don't like those situations very much, and I don't always follow this advice, but I had a lawyer tell me one time that if I'm faced with that situation and where there's a serious disagreement, I'm not talking about something that's peripheral, that I should write a honest and detailed letter expressing my opinion to the client in such a way that it will either inflame the client and they'll fire you, which isn't bad, or they'll agree to what you suggest.
Yeah, I agree, and I'm not really big on the written email and or letter you just mentioned. you got to cover yourself. It's also your perhaps last ditch effort to convince your client and/or anybody associated with them that this is a very well logically thought out position that you're taking. I think it's very, very important to do that. I don't think it's worth representing a client, and again, we all make exceptions sometimes when the dollars attached to the client are quite large, let's be honest. But there's a line there, there's an important line there. And I think the longer you're in the business, I think the more equipped you are and the quicker you are to expunge that kind of relationship, because it's just not worth it. It's just not. There's too many potential headaches that could evolve from it. And it's better and more important, I think, to focus on clients who I think are going to take your advice and counsel. Not that you're always right about everything, but you're there to learn and to listen and to allow you to do your job.
I appreciate that. And our role as lawyers, you have to counsel your client. The reason you hired me is for my knowledge and expertise, and you have to, and my duty is to really be objective about this, and that's the value that I can add to that. So one of the best things we can do for our clients at times is to tell them no, and that's in their best interest.
In my business, that's critical. There are fairly a low percentage of people in my profession to do that. Most people in my business are yes men, and they're usually, backing up constantly from positions and/or you have to, as I said earlier, you're either going to take an educative approach or a sales approach. Realistically, fall somewhere in between depending on the situation. But I am far more inclined to take an educative approach because you tend to, I think, potentially attract better clients if you do. And therefore you have less headaches down the road.
We're getting close to the question and answer time, so I'm going to ask one other question of the panelists, and that is, what is the future of arbitration? And one of the things that I've been following is the recent NLRB Northwestern University student athletes situation. I think that's very interesting, and the different student athletes that have started to demand that they be compensated in some way.
Okay. So there's a lot going on in college sports, and this question of should student athletes be paid, and if so, just the revenue sports, men's basketball and football. And you're probably familiar, I think your law review conference coming up is on the O'Bannon case and the student likeness litigation. So they're seeking to be compensated in the lawsuit for use of their images on video games and broadcasts. But the Northwestern, and they're backed by the steelworkers, and there's a college athletes player association that wants to be formed. So they want to unionize the revenue sports in college sports. So they filed a petition with the NLRB to be certified as a union, and there's some precedent because at I think NYU graduate students have been considered. So the question is, are student athletes considered employees? And they have some precedent on their side in terms of the definition of employee control of so NCAA, the institutions are very much opposed to this because the precedent was set. But if we had student athletes certified as a union, then it would be similar to the model in the pro sports, where the union would engage in collective bargaining with the institutions on terms and conditions of employment. And I'm not sure if they're seeking compensation in this petition, but that's part of it, the full cost of attendance. Not everyone has the Ferrari leather seats that you guys have. I've seen your new athletic department. Dang, that's oh, okay, so sorry.
No, I mean, the simple question about arbitration is that it has just as much a place now as I'm sure as it will tomorrow, perhaps even more so, for reasons the rest of the panel can speak to more intelligently than I will say this, though, on the topic of college and the potential, dramatic changes that are on the horizon. I think it's incredibly interesting. If I were in your position right now, I would really delve into it. This is going to be, in my opinion, it's going to open up, and there's going to be radical change. And I mean, this is a topic that's near and dear to me for so many different reasons. Having experienced what I have as an agent for 25 years, and having represented head coaches in college, the fact is there's potential for some kind of privatization. There's an array of complex issues that only the youngest legal minds, I think, are going to be poised to handle appropriately. I just think there's tremendous opportunities out there, and the more you guys can come together and talk about it, the better, because we need to have change. To be perfectly honest, as far as I'm concerned, it's a farce, an absolute farce. And so changes need to be made. It's complex, it's not easy. There are a lot of issues that need to be handled, but I think if people really are thought sensitive and think practically about it, I'm already having more conversations about it now. My former partner, good friend Ray Anderson, is now the athletic director at Arizona State University, so he's going to get an earful from me now. He just left the NFL. But I had this conversation with a lot of people, and I strongly encourage all of you to give it some thought. If you have interest in sports, to me, there are some avenues that you have to be created that I think you guys can take advantage of.
I agree that there's always going to be a role for arbitration. I think in businesses, for the reasons that have been stated here earlier, prefer that arena in many cases for its confidentiality and also its finality. And with respect to sports leagues, those two reasons come into play as well. The unions and the leagues like it for those reasons as well, for expedited resolution of disputes in confidence. Arbitration is a good way to go. If I was considering entering into the consumer law field on the side of the consumer, however, I might not be so enamored of arbitration because the arbitration agreements are drafted by expensive lawyers representing businesses, not consumers, and it's not a very consumer-friendly environment frequently. The arbitrators are more, in my experience, beholden to the business world than they are to the consumer. And if I need a fair shake, I'd rather take my chances in court as an individual.
And I just want to second what Kevin said. For many years, I was an active member of the Oregon Trial Lawyers Association, and as far as consumer rights are concerned, arbitrations typically are not viewed as remotely helpful to consumers. Court is a much better forum for consumers to be, and also for class action lawsuits. But I think for certain types of relationships, it really does make sense. I think it's going to continue. I think that we probably will see more arbitrations in the future in greater areas of law. We are seeing them more even with employment disputes, with individuals who sign employment contracts with an employer when they were first hired, and then later if there's a dispute that comes up over termination or something, it goes to arbitration. And I think that those often can be handled fairly through an arbitration setting. And I just want to say, as a final thing, I'm actually very excited about this NLRB case. I do think that with the professionalization of college sports and the demands on the student athletes at many schools and many of the sports, there needs to be something that helps protect those athletes from exploitation. Because I personally think that there's a big problem with that at many of these schools.
Now it's time for Q&A, so if anyone has any questions, please raise your hand. Not all at once.
This is a follow-up to what you were just talking about, whether arbitration is really better than going to court. I represent public venues, and I stripped out all our arbitration clauses. I'm going to try to pull in like a New York promoter in Walnut County and have some professional judge who's going to a large firm arbitrate the case. And it's interesting. I think it's a labor context. Arbitration makes sense. It's quick. It's a relationship. In a commercial context, even outside of consumer law, I'm not so sure arbitration is the best place to be for everybody. I'm just interested to hear a little more go ahead and talk about it.
Well, since I'm the one who first brought that question up, I would say that if both sides of a commercial dispute are interested in confidentiality, and oftentimes they are, then arbitration is obviously the way to go. It's not a public forum. But sometimes that's not the case, and it can be a situation where one side of an industrial or commercial business is generally more interested in confidentiality than the other side.
From my perspective, I have not had an employment case where it was like, employment discrimination or something like that went to an arbitrator, although I have had several colleagues who have. And frankly, they had a lot of anxiety before the actual arbitration occurred, but felt actually pretty good about the process and got good results for their clients, and this is individuals representing plaintiffs in employment disputes. So at least in Oregon, I think there's a good enough panel of arbitrators who can hear these disputes and who have some knowledge of how to look at the evidence and what rules to apply, that I think the process can be relatively fair. But you always do have to know your audience, and you also, it is very different than convincing a jury. I think in some ways, depending on what kinds of facts you have, if you're in an employment case, it is more difficult to convince a jury than an arbitrator. Having tried cases in front of administrative law judges in the federal system and the state system, I think in many respects it's easier to get that one person to decide in your favor than to get a jury of 9 people to decide in your favor, but you have to have a unanimous verdict in federal court.
If I could
I think you raised a good point on employment cases, because I spent a lot of time fighting employees getting things back in arbitration, and spending a lot of money fighting to get back in arbitration instead of court. And then most of the time, arbitrator, like you already said, is what the litigating and then they want fees. So I don't think necessarily it's bad. They end up being worse for actually. But they get a good so.
I just wanted to add that I think the benefits of arbitration very much apply when the parties are entering into the process voluntarily, knowingly, and you have a neutral decision maker. So there's the concern that was raised about the repeat player in consumer employment. The consumer goes there once, but the business is continuing to hire the arbitrators, and if that's their business, you have a potential bias to favor the parties going to be hiring or recommending you in the other context. In the sports context, in the program, and NLRB certifies college athletes, then the union acts as an equalizer. So when you have an equality of bargaining power, then the process can work now. You have advocates on both sides. The problem in the employment consumer context and with international athletes, there's a disparity in bargaining power, and so with those other process concerns, and everyone here is probably, I'm sure, if you have a cell phone, you're a party to an arbitration contract, it's probably in your lease. So arbitration is ubiquitous in our society right now, and so you should all know how to represent clients in arbitration and know that process. But we have a Supreme Court right now that loves arbitration. So they are enforcing bans on arbitration. So your contracts will say you are bound, any disputes are resolved in arbitration, and then they can say what the terms are, and you can proceed only in an individual capacity, no class action. So class actions are being wiped out by contract in the Supreme Court. See the AT&T Concepcion case, which also says the risks of arbitration are grave to the company when, why would the company bet itself on a class arbitration? So it's interesting that they're talking about arbitration as the new litigation. So corporations, when they're dealing with each other, are now choosing to go back to litigation where they have the rights of appeal.
Okay, we have time for questions. Okay, does anyone have a question? If not, let's go. Thank you very much. All right, thank you very much, Alice.